U.S. Judicial Branch and Checks and Balances. Judicial Review, Part 1. Judicial review is the method by which the judicial branch reviews the actions of the executive and legislative branch, like finding a law unconstitutional. The judicial branch interprets laws, and so we want to talk about the judicial review power and where it came from. The Constitution has a clause called the Supremacy Clause, and it reads like this: "The Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, any thing in the Constitution or laws of any state, to the contrary notwithstanding." What does this mean? What this means is that there's a hierarchy of the different types of laws which exist in the United States, and up at the top is the U.S. Constitution, the supreme law of the land. The Supremacy Clause tells us that this is higher than federal laws and treaties, which are higher than state constitutions, which are higher than state laws. So if you're thinking about preemption and the idea of what type of law is going to beat out other laws in terms of how strong it is in the governmental system, this is what the pyramid looks like. A state law will be overruled by a state constitution, and both state laws and state constitutions would be overruled by federal laws and treaties. This is the idea of preemption. And at the very top is the U.S. Constitution. The Supremacy Clause says that there is no law above the U.S. Constitution, and it is the supreme law of the land. To understand this, let's talk about courts at the times of the Founding Fathers. It was interesting that states had their own court systems, and they had their own constitutions going on at the same time. And so in this new government, where we sought to create a federal government with its own constitution, we had to contend with the fact that a whole different set of laws and court systems was going on in 13 different states. We had issues with state laws or state constitutions being decided by the state courts. And so we needed to come up with something that was going to decide the manner by which federal laws were going to be decided. At the time, the federal Supreme Court had powers which were allocated to it by Article 3 of the Constitution. Article 3 of the Constitution specifically says that the federal Supreme Court can deal with cases affecting ambassadors, and deal with cases affecting other public ministers and consuls, and it can also preside over cases in which a state shall be a party. But this is all it said. Nowhere in the Constitution does the Supreme Court get the power to judge Congress's laws to determine whether or not they are constitutional. In fact, Article 3 specifically only gives the court power to hear appeals in certain cases, except when Congress makes an exception. So Congress can even say when they don't want the federal Supreme Court to hear or to review a law which they've made. In other words, we have state Supreme Courts which can review the laws of their legislative bodies for constitutionality and decide whether or not the state laws are constitutional by the state constitution standards, but the U.S. Supreme Court couldn't do that. All it could do was hear appeals cases, could hear cases dealing with ambassadors, and hear cases where Congress had not taken away their power to do so. In other words, we had a very weak federal Supreme Court versus the state Supreme Courts, and this had an effect on not only the strength of the judicial system in the federal courts versus the state courts, but in terms of the federal courts having their power distributed between the three branches of government. Remember, at the time we had a concern that the federal government would have an executive branch, a legislative branch, and a judicial branch would be fighting for power. So now we have a system where we've created a national judiciary, but with this judiciary, they don't have a lot of power. And so we want to talk about what's going to be the problem of having a weak judiciary and what this meant for the idea of judicial review.